Just it's important. It's important to call boys boys and girls girls. When we don't, when even Christians who believe what is true about sex and marriage and all of these things, God-given identity, when we start to use this language of cisgender or trans boy, or even honestly, I was thinking about this recently. I don't like the term biological sex, because biological sex implies that there's another kind of sex, right? There's the sex that you have biologically at birth, but then there are these other factors that can make your sex something other than that, and that's not true. There's not biological sex, biological boys, biological girls. There are just boys and girls. There are just men and women, and I think it really muddies the waters and makes it hard to argue for the true things that we have to say in this cultural moment when we're using language that is invented by opponents of what is true about sex and God-given identity. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. This week, we'll be covering, or to start with, an emergency appeal that was filed to the U.S. Supreme Court in California to protect kids in public schools from transgender ideology. Then we'll stay generally on that topic and discuss last week's oral argument at the Supreme Court in two cases, Hecox and VPJ, that involve boys participating in girls' sports. And then we'll conclude with some encouraging, though modest, conscience protections and parental rights pro-life legislation in New Hampshire that is currently pending. All right, so let's start in California. So for a bit of backdrop, California law currently requires public school staff to treat their students like they're members of the opposite sex upon request, and to conceal those decisions from the child's parents. So basically, you have these situations that have been common in news stories and lawsuits over the last couple of years of school districts basically honoring children's decisions regarding their so-called gender identity and actively having policies that tell the teachers not to share that information with the parents. So there have been, as we said, several lawsuits, several news headlines over the years about fights over these policies in other states. The current appeal from a group of teachers as well as parents in the California case Mirabelli versus Bonta, we think is worth paying attention to, both because of the unique posture of it and how egregious I think California's policies are, but also because of the free exercise argument that's being put forth. And that's what I'm going to focus most of my time on here. So just as background, some of the examples that come up in this case are pretty egregious. Some of the plaintiffs were informed, the parents, that their daughter had been treated as a boy at the school for over a year. The parents were only told that after the daughter attempted suicide. Another set of parents in this case are devout Catholics whose middle school age daughter was secretly treated as a boy at a public school. And these parents apparently don't really want their child in the public school systems in California, but are unable to pay for private education. And this is ongoing. The school districts have doubled down. The state of California has doubled down that parents are not going to be informed unless there's a compelling reason, which is in the policy. It's interesting, and that actually plays into the case a little bit. There are some exemptions, but it doesn't seem like there are any criteria telling teachers when there is a grave reason that they do have to tell parents. So that's one of many things that is problematic here. And then to make this a little more interesting and complicated legally, besides the parent-teacher issues, there are also teacher issues. Mirabelli, who's the named plaintiff in this case, is a teacher at a public school who is being told that she must follow this parental exclusion policy. So if she gets a confused student who claims that he or she is a gender of other identity other than the child's sex, the teacher, even if she feels compelled by her religious belief or just sanity that this should be shared with the parents, is unable to do so and must follow this policy. There's no apparent religious exemption for teachers to this policy. So this issue ended up in court. The district court, the federal district court, actually did enter an injunction against enforcement of this policy, but the Ninth Circuit stayed that injunction and kept this hide the identity from parents policy in effect. So earlier this month, the plaintiffs filed an emergency appeal to the U.S. Supreme Court asking for the original injunction from the district court to be reinstated, and so for the Ninth Circuit's stay to be vacated. So here we are. There are several legal arguments going on. There are a couple that I'm just going to gloss right over because I want to focus on one religious liberty argument that I think is interesting and continues the conversation in an area that we've been following for quite some time now. So there are religious exercise claims and there's a due process claim. The substantive due process claim, I think it's interesting. The claim is basically that the liberty, right, that is protected by due process, in this case, substantive due process, which we'll put aside the fact that I think unenumerated rights don't belong in substantive due process. If you're the kind of lawyer who listens to this podcast or you've listened to it before and you've heard me talk, you probably know what I think about this. I'm actually with Justice Thomas that these kind of unenumerated rights belong in privileges or immunities, not due process. Nevertheless, we have this regime of finding constitutional unenumerated rights in the due process clause. And if liberty is one of those rights, the argument here is that that liberty interest includes the right to have a family, which is there's precedent for that. And with that comes the right to exercise control over major decisions concerning one's children. So that's the basis for the due process claim. I think it's a pretty good one. If the court is going to articulate unenumerated rights, we definitely think strong parental rights belong at the top of that list. And then on the other side, we have more than one free exercise claim. And the gist of this argument is that, right, due to the fact that, well, there are a couple. So one that I'm not going to spend much time on is interesting. I mentioned this before that there are individualized exceptions available to this parental secrecy policy, but there's really no standard. Like the school district or the school board admits that there's no standard. It's a standardless exemption. Um, the relevant policy here states that parents can be informed of their child's gender transition if they have a specific and compelling need to know. There's nothing guiding what a specific and compelling need to know would or would not be. So it's pretty clear that there could be, health reasons, or as one of the cases that we mentioned a minute ago, if a child like commits suicide or expresses self harm interest, maybe then a parent needs to know. But the school district gives no indication that if parents have a religious objection to these kind of gender ideologies in the first place, that would be a specific and compelling need to know. In fact, some of the policies make it likely that those are instances where the California policy would not want the parents to know. There's no objective standard to determine this need to know thing, so strict scrutiny is triggered on that grounds alone. But I want to focus on a different free exercise claim that I think could have the most impact for future precedent if the Supreme Court accepts this question for review. So the argument here, and it's the first one in the appeal. I believe it's around like page 18 or 19 of the appeal brief. So if you want to look at it, it's really worth reading. So the argument traces a line from Wisconsin v. Yoder through last year's Mahmoud v. Taylor case to the present case. I think the argument's quite good and is very interesting. So quick review: the Yoder case, 1972, I think. So this was the case of the Amish parents in Wisconsin objecting to having their children attend high school and be in an environment hostile to Amish beliefs, even though the law was that children had to stay in school until I think it was 16. So the Amish said, "Well, no, we take our kids out by high school. If our children, our Amish children, go to high school, they'd be pressured to conform to worldviews that are in conflict with our Amish beliefs." And in this case, the court in Yoder held that strict scrutiny applied because the modern high school is not equipped in curriculum or social environment to impart the values promoted by Amish society. So there was a religious right to opt out of the schools. Um, and the takeaway there is if school policies conflict with the religious beliefs or practices of parents, strict scrutiny applies to those tensions with the religious beliefs of the parents. So the Mahmoud v. Taylor case last year made a couple things clear. Everybody's probably familiar with it. That was the quite graphic same sex and gender stuff, was in elementary school books, and there were no opt out provisions available for religious parents. And Mahmoud did a lot of things. First of all, it struck down that ability of the schools to impose this graphic, ideological sexual content on children with no opt out provision. But Mahmoud did two things that I think are relevant here. One, Mahmoud made clear that Yoder is still good law, which there were some questions about, especially after Employment Division versus Smith. And also, as the brief says in the argument in this case, most recently, the court in Mahmoud has instructed that when the government substantially interferes with the religious development of the parent's children, which I think is clear here, then we need not ask whether the law at issue is neutral or generally applicable before proceeding to strict scrutiny. So that's important because you do have this Smith problem where you could always raise if you're opposed to the religious exercise claim, right? Well, I mean, this is, a California policy about keeping children's rights to be whatever gender identity they want to in school without telling their parents. Um, it doesn't apply only to religious children. It's not particularly targeting religion. It's neutral, generally applicable, which obviously is a problem because this affects religious parents differently than maybe secular parents who don't care as much or at all about this issue. But regardless, in cases like this where you're talking about the development of parents' children, the court has made it clear that strict scrutiny does apply. So then I think the argument in this case here that's pending before the Supreme Court is pretty straightforward. The way the brief writes is here, the school's facilitation of a secret gender transition for young children, which may have permanent and life altering consequences, is orders of magnitude worse than the burdens imposed in Mahmoud and Yoder, right? If Yoder says that if parents are opposed to the environment of the school or to kids being in school beyond a certain age at all, they can opt out of school. Mahmoud says that if kids are being exposed to this objectionable ideological content, parents can opt out. Here we have something much more dangerous, right? Than mandatory attendance or even explicit content. We're actually talking about schools facilitating children making harmful decisions and not telling the parents about it. So arguably this is worse both in the burden on free exercise and also in the danger to the children. So if this is accepted, I think this will be an important um, a chance to answer this question that's been going on constantly, right? The who makes these decisions, right? Mahmoud v. Taylor brought us a pretty long way with a majority opinion from the Supreme Court that no, it's parents, not schools, that have the ultimate say over important decisions about children, especially involving religious questions. I think this is a pretty straightforward way to apply that and continue to say no. Schools do not have any ability to bring in teachers and social workers and have these secret programs where you call a boy she or her and don't tell the parents about it. I mean, this is so egregious. Um, and hopefully, this will be a vehicle for the Supreme Court to step in and say, no, we're going to continue the religious exercise jurisprudence of Mahmoud and of Yoder and say, no way. Like, parents absolutely have a right to hear about this stuff. And they're the primary people who should be involved in these decisions for their children. They certainly touch on religious questions about sex and biological reality and the God givenness of male and female sex. It also just, I think this will be another one of those cases that will garner public attention and say, hold on, even if we're not hardliners on this issue, this seems kind of crazy that schools are doing this and not telling parents about it, right? So, to finish up on this one, procedurally, this appeal is asking the Supreme Court to vacate the Ninth Circuit's stay, which would put the injunction against enforcement of this law back in place and prevent gender transition information from being kept secret from parents. The way this petition wraps up, the petitioners also asked that the court construe this application not just as an emergency request to vacate the Ninth Circuit stay, but also to construe the application as a petition for writ of cert before judgment. So they're also asking, we want the Ninth Circuit's crazy stay vacated, but we would also like this to go up on cert to answer these questions before the district court and the Ninth Circuit have a chance to weigh in. So big deal. We've had several circuits take a look at these kind of issues. Whether the Supreme Court will vacate the Ninth Circuit's decision and or grant cert on this case remains to be seen, but it's definitely one we're going to keep watching. So, Joseph, what do you think about what's gone on here in California in the Ninth Circuit?
Yeah, Frank, thank you for kind of outlining things there. And there are a few similar challenges, like you said, like Mirabelli, that have also failed at the circuit level and are currently pending before SCOTUS. And they have similar fact patterns. In Little John v. Leon County, we covered that one a couple months ago. The parents lost because of the circuit basically applied the shocks to conscience test which basically says that when there is a fundamental unenumerated right protected by substantive due process, when that's implicated by executive action, there's this highly deferential standard that basically says you have to prove that the state actor acted with intent, with malicious intent. And because of that, they said the school administrators are trying to help these kids when they're calling them these fake pronouns and doing these terrible things. And because of that, the law was upheld. In Foot v. Ludlow, there was kind of a dissimilar parental exclusion policy that was challenged, and then they actually said that that doesn't the parental exclusion policy doesn't implicate a right protected by substantive due process because calling kids by names is like something everybody does. It's not a medical thing, so it doesn't implicate the right to direct medical care of your child. And this one, like you explained, is a bit different legally, but it also further shows the urgency, I think, of why we need to get rid of these terrible and deceitful policies that cut parents out from their kids' lives. Like you said, one of the plaintiffs only discovered the child's mistreatment at school after the kid attempted suicide, which, I mean, in what world should you wait when there's these warning signs to tell a parent until there's an action like this? Other parents are financially unable to move their kids out of public schools even though they've moved from school to school within the state, all the states are subject to the same guidelines. So for some parents, it's impossible to get their kids out of this type of situation. And this case shows that. And just the boldness of some of these state officials is on further display. There was an instance, there are some court documents outlining how some of the parents emailed the school and said, you have to stop calling our child by the opposite pronouns. And very flatly and very boldly, the school replied, we have legal protections and will continue referring to your child by, I forget if it was a boy or girl, but by the child's preferred pronouns. And it's just the boldness and egregiousness of this activity by the schools is horrible and it's deeply damaging. I mean, talking about an emergency appeal. Um, in just about, broadly speaking, every situation where there's people in positions of authority over vulnerable populations, more oversight is called for. Here we have adults that run a school that interact with kids that are very vulnerable, very sensitive. They're often depressed, confused, unsure of who they are. And here public officials are saying, we want less oversight. We want less people looking at what we're doing, and we want less parents involved. And that's just so deeply alarming that I can't fathom any justification for these policies. Um, it's shocking and horrible that these school boards want their actions hidden from parental control and scrutiny when they're dealing with such a vulnerable population. So regardless of where you stand on these issues, just the fact that they want to cut parents out of this vulnerable topic doesn't make any sense. So with that, we'll move into our second update, where last week the U.S. Supreme Court heard oral arguments in a pair of consolidated cases that will determine if states can maintain the integrity of women's sports. Most of our listeners are probably pretty familiar with Little B. Hecox in West Virginia v. BPJ, and oral arguments were over 3 hours, and I'm not going to talk about everything that happened, but there were a few crucial points that came up that I do want to spend some time on that aren't getting as much media attention. So with that, let's get into the cases. So for some general background, among several other states, I think the number's in the 20s. Idaho and West Virginia currently ban currently ban men who identify as women from competing on sports teams reserved for girls and women. These laws were challenged as alleged violations of due process in Title IX. Title IX prohibits sex-based discrimination in programs that receive any federal assistance. And both states lost at the circuit level, so different circuits ruled that these laws were unconstitutional. On the due process claim, this really came up in the Idaho case. That's Little B. Hecox. The court determined that the Idaho ban subjects only some students who want to participate in female sports to go through these invasive sex verification processes. They're basically saying that if you have these males that want to compete against females, you're making them go through exams or blood tests and that sort of things to verify that they've eradicated their biological advantage. And also the court ruled that the Idaho's ban categorically prohibits, the court used the term transgender girls, really it's males who claim to be females, but it categorically bans this one set of people from female sports, therefore violates due process. As regards the Title IX issue at the circuit level, this was really in the West Virginia case. That's the BPJ one. The lower court said that nobody can be excluded from participating in a program that receives federal assistance based on sex. That's Title IX. In this instance, the attorneys are arguing that the plaintiff was treated worse because of his, and that's the biologically accurate pronoun, because of his sex. So that's where the Title IX issue came in. So moving into oral arguments and where this case is at today. Again, they were 3 hours long, so we don't really have the capacity or time to go through everything that was brought up. But I do want to focus on a key point that came up from the Solicitor General's office. That really has two aspects. The first is pretty simple. The law turns on sex. That wasn't super disputed. And because of that, intermediate scrutiny as opposed to strict scrutiny should apply. And they're arguing that the bans satisfy intermediate scrutiny. So for the first point, the law turning on sex, again, that wasn't super disputed. Basically, it bans men from women's sports or boys from girls' sports. The operative distinction is men/boys, which is clearly sex. That wasn't super disputed during oral arguments or in much of the case. Really, what was talked about by the SG's office was this intermediate scrutiny point. So the office is arguing that historically, for sex-based classifications, the court has applied intermediate as opposed to strict scrutiny. I'm sure the vast majority of our listeners are familiar, but for anyone kind of new, basically strict scrutiny says that when a law is challenged on constitutional grounds, it's analyzed under strict scrutiny in some instances, which requires a compelling government interest, and the law in question has to be the least restrictive means to accomplishing that interest. A lot of times, the way this plays out is that a court will apply strict scrutiny, kind of assume the compelling interest part, and then say this isn't the least restrictive means to accomplish it because there's some other way to achieve this ends. And then more often than not, whatever law is challenged under strict scrutiny gets struck down. Uh, and here, the big difference with intermediate scrutiny is that only a uh, important government interest with a substantially related means to achieving that interest. So the operative distinction there between intermediate and strict scrutiny is there's no longer this least restrictive means requirement. It's substantially related. So what's happening here is that both states have this important interest in maintaining fairness, equal opportunity, safety in girls and women's sports. And in order to accomplish this interest, their substantially related means is banning males from these sports. And because strict scrutiny shouldn't apply, you don't need a perfect fit, you need a near perfect or a substantial fit. And that there's clearly a reasonable fit between the state's interest in protecting women's sports and banning men from these sports. To add a bit more color and authority to this point, the DOJ's amicus brief said that basically, while the Supreme Court has held that excuse me, I'll just read briefly from it. While the Supreme Court has held that the Due Process Clause invalidates sex-based classifications that do not satisfy intermediate scrutiny, so that first half is saying intermediate scrutiny does apply, um, quote, it cannot possibly be construed to require preferential treatment for male trans-identifying athletes that places females at a disadvantage in competitive fairness and safety. So intermediate scrutiny has applied, but we cannot misconstrue the Due Process Clause as requiring preferential treatment for this subset of people. Chief Justice Roberts addressed this point during oral arguments when he told an attorney representing one of the men who want to compete in girls' sports. He says that it sounds like you're trying to apply strict scrutiny to a type of challenge that we've never applied to it before. So, kind of the long and short of that is the Solicitor General's office really zoomed in on the point that, historically speaking, sex-based classifications trigger intermediate scrutiny. These laws have a substantial interest, an important government interest in protecting women's sports, and a very easily substantially related means by banning men from those sports. So it's kind of a simple series of arguments. The level of scrutiny that should be applied is far less demanding from strict scrutiny. And really, the only way that these laws can be struck down is if you apply something that looks like strict scrutiny, which doesn't really make sense with what the court has done in the past. So, Frank, that's what I heard from oral arguments. I'd love to hear some of your thoughts on what's going on here.
Yeah, I always enjoy this dynamic now, how I'm the lawyer, but you're the one who gives like the technical legal breakdown of what happened here, which is great because you did a good job of laying out the basic legal issues, and it gives me some room to just, I think, make a couple of cultural bigger picture points here. So maybe we'll get a clip out of this. We'll see what I say. But just really briefly, I mean, I think I won't say where I heard this from, but I was following in the wake of these oral arguments last week. Some commentator who I respected basically said, I have a hard time getting excited about these cases because it's hard to take seriously the fact that we live in a republic where like the Supreme Court has to weigh in on whether like boys can play in girls' sports. And it is to me as simple as that. Like obviously there are legal issues about levels of scrutiny and discrimination on certain classes, and like these aren't meaningless, right? Because there's precedential effect on how you answer these. So when absurd claims come up, they need to be resolved. But to me, I mean, it's just a completely absurd claim, and it's an ironic one because the whole like civil rights era, a lot of the the purpose of these protections for women in the Civil Rights Act were to ensure that women had the ability to do things like play sports. And so you've had like decades of movement to have, women have their own place in sports because obviously, as you said, there are massive biological differences between men and women. And if you had just a league for all sports where there is no sex classification and everybody just plays according to merit, you're not going to get a whole lot of women playing a whole lot of sports, right? There are some where women can be more competitive, where physical advantages are different, but for the most part, these sex-based divisions are necessary to have women's sports at all. And I think everybody sane kind of realized that until very recently. And now these ideological things come up, which you can call it trans rights or what have you. But I mean, this is boys trying to play girls' sports. And that's my other point that I want to make that I think is a real big issue that it got some media attention after these arguments, but I think it bears repeating and emphasizing that I think Justice Barrett in particular has emphasized that in her concurrence last year in Scrimeti, that she wanted to come out and say transgender status is not a protected, a suspect class warranting these heightened levels of scrutiny under the 14th Amendment, which is great. But I think taking the legal standards aside, we've the Christians in this religion world and religious liberty spheres in general have had this problem for a long time of unwittingly using language created by enemies of religion and of sanity a lot of the time. So when language is being rewritten in dangerous ways, it is quite important that we use language carefully and not use um, language that is harmful to our own articulation of what is true and what is good. And I saw a lot of it in the oral arguments, right? I think Justice Barrett in particular, although a couple of the justices were the Republican appointed justices were doing this as well. Um, Referring to, boys that identify as girls, as trans girls, things like that, cisgender, this made up term for people who are not transgender, basically, who identify as the sex that they actually are. So it's important. It's important to call boys boys and girls girls. When we don't, when even Christians who believe what is true about sex and marriage and all of these things, God given identity, when we start to use this language of cisgender or trans boy, or even honestly, I was thinking about this recently. I don't like the term biological sex because biological sex implies that there's another kind of sex, right? There's the sex that you have biologically at birth, but then there are these other factors that can make your sex something other than that, and that's not true. There's not biological sex, biological boys, biological girls. There are just boys and girls. There are just men and women, and I think it really muddies the waters and makes it hard to argue for the true things that we have to say in this cultural moment when we're using language that is invented by opponents of what is true about sex and God given identity. So again, don't want to be overly critical, and I think Justice Barrett is probably on the correct side of this particular case, but I get very wary. And people interested in this, the importance of the true and proper use of language, would do well to read Professor Helen Alvarez's book, which I'm blanking on. I'm trying to find. I was looking behind me when you were talking, Joseph. I'm trying to find a copy of the book. Um, if I remember the name of it in the next few minutes, I will plug it. But she has a book about just this topic, like the proper use of language and arguments, framing them positively based on true language and not accidentally adopting categories that are harmful to the truth. So I suppose I will leave it there. Again, very good analysis, Joseph, of the legal arguments. I just think it's worth pointing out some of the cultural realities at play that are very fundamental and honestly very disturbing. When you have the Supreme Court arguing about whether boys can play girls' sports, whether a trans girl can do something or other. That these are very fundamental questions of what it means to be a human person, and to have these things be up for debate in the U.S. Supreme Court is just feels a little like Alice in Wonderland.
Yeah, just further to that point, there was a kind of comedic exchange between Justice Alito and one of the attorneys representing the boys and men who want to play in those women's sports. And he basically asked them, in order for us to determine if something is, a sex-based classification or something along those lines, we needed to be able to define sex. And through kind of a couple questions relating that, he ultimately got to, can you tell me what a boy is or what a girl is? And the attorney kind of dodged it and said, well, it doesn't really matter here. We're not really deciding on that. But like you said, the truth is we need to use terms that reflect reality. And when we're having attorneys in the Supreme Court arguing before the Supreme Court refuse to answer what a boy is weird to see, and it's alarming.
Yeah. No, you're right. And I'm glad you highlighted that to finish off this conversation because the answer to that question that Justice Alito is poking at, it does matter. Because if you're just going to say proponents of this gender ideology cannot give a definition of what is a boy, what is a girl, what is a man, what is a woman, um, then you basically, I don't think, have any choice but to dissolve sex-based distinctions in things like sports, because, or else, what is it? Whoever says they're a boy or a girl is that? Like, if right, a 250 pound man who is 17 years old, has lifted weights for years, is huge and muscular, and has done nothing to quote unquote transition, right? If he says he's a girl and you say, well, no, you're not, okay, then you're back to this question. You do have to answer what a girl is because you've said that this guy is not, but then there are other boys who identify as girls who are girls. So then the proponents of this ideology eventually have to answer this question, right? You can't just keep saying we don't know, it doesn't matter. It does, because if it doesn't matter at all, then there is no answer and you just have to break down the distinctions at all. But if you want to say that, like, well, if you're under a certain level of testosterone, or if you've been in hormones for this long, or you've had these mutilative surgeries, if that's what makes you a girl, okay, but then you still need to define what a girl is, right? There's a problem here. You do have to do that analysis and to put down a definition. And of course, proponents of this ideology don't want to do that because you're obviously then in a relativist mess, and you're never going to come up with a definition that's anything other than arbitrary. And I think they know that. At least some of the proponents of this know that, and so that's why they do things like what you just pointed out, like go before a justice of the U.S. Supreme Court and say we don't know what a boy is or a girl is, but it doesn't matter. Anyway, now we will flip quickly to New Hampshire and get away from the trans issue for just a couple minutes. This will probably be a quicker analysis, but I do think this warrants some attention because this is going to start. I think this has been in the news a little bit. Um, it's interesting for a couple of reasons. For one, because it's going to be misconstrued as a, aggressively anti-abortion set of state laws, which it isn't. And it's also interesting because it's taking place in New Hampshire, which is generally a more libertarian but not particularly social conservative state in the policies it enacts. So I think this is interesting. So abortion in New Hampshire is legal until 24 weeks of gestational age. It's been that way for quite some time. Um, but two state bills, modest state bills, I think, have recently been passed in the House and then in the Senate with an amendment. So the process is kind of ongoing, but they're worth highlighting. So two different bills here. You have HB 232, which states that any healthcare provider who refuses to abort an unborn child cannot consequently face retaliation from his employer or from his certifying board as a doctor, right? There are a couple of exceptions. This doesn't apply to doctors who work in centers that provide abortion as a major part of its services, their services. So that one, I mean, as horrible as this whole regime is, but that makes sense, right? If you're a doctor and you're being pushed by your employer to perform an abortion, if you work at a hospital or something like that, you should get conscience protections and you can't be retaliated against. Makes sense. If you work at a Planned Parenthood, this law is saying, well, that it doesn't apply to you because Planned Parenthood really just exists to perform abortions. So again, as hideous as this is, it kind of makes sense that you can't go work at like an abortion clinic and then opt out on conscience grounds from being involved in abortions. So that is what it is. That's one of the exceptions to this bill. The other one is if the doctor is the only one present in an emergency situation, then he can't refuse to perform the abortion. Now, I want to touch on this one before we go to the other bill, because this gets us back to a questionable use of language surrounding abortion. That actually, Joseph, you referred to this, I think, last week in our episode about the whole life of the mother exception, which I think is extremely problematic, right? So, probably a good example of what we were just talking about of adopting the language of opponents of what is true and opponents of religion and religious exercise. Um, Life of the mother abortions are largely a fiction. There are probably no examples where a direct abortion, that is, a procedure precisely to kill an unborn child, is necessary to preserve the life of the mother. That's distinct from a mother getting cancer treatments where the indirect effect is going to be that the child in the womb dies, or that's not an abortion. So again, life of the mother abortions, I think, is misleading language. I think this one is an example of the same thing. If a doctor is the only one present in an emergency situation, I mean, what are we talking about? Because what opponents of these bills will try to say is, oh, so if a woman comes in and she's miscarrying, a doctor, that's an emergency situation. Possibly true, right? But if the doctor can't, if he opts out on conscience grounds, then it's going to kill this woman. It's like, that's not participating in abortion. Pro life doctors are not opposed to helping women who are miscarrying or dealing with situations involving ectopic pregnancies and things like that. So, this is a misleading use of language to say that there are going to be emergency situations where a woman needs an abortion in an emergency. And if the doctor's the only one on call, then if he objects, it can endanger her life. So that it just doesn't really happen from what I've read. Again, I'm not a doctor, but it seems to be a misleading way for pro-abortion advocates to try to fight against conscience protections. So that's the one bill, 232. HB 191 is a separate bill, but they were passed around the same time here in New Hampshire. This one, which most states have in some form, makes transporting a minor for an abortion without her parents' express written consent a crime. So it's a misdemeanor. Repeat offenses can be a felony. Basically, if you're an adult who's not a child's parent and you bring that child to get an abortion without the parent's knowledge, that's a crime. That's what this bill would do. Um, this one, I believe, has passed both the House and the Senate. I believe there was an amendment on, I think it was the first one on 232, where House passed them both first. The Senate amended one, and then it's been sent back to the House. Once that's hopefully passed, then they'll go to the governor's desk. So, just a couple things I would note here. First of all, as I said, New Hampshire is not a typically socially conservative state, but this is not an abortion ban, despite some media screaming. I know there have been some people, pro abortion folks, and a Democrat legislator in New Hampshire had said something like, make no mistake, this is an anti abortion bill, but not really. These are about parental notification and about conscience protection for religious or otherwise objecting doctors. So again, these aren't actually restricting abortions. Um, the other interesting thing to note is it's always a question in a place like New Hampshire. Um, whether people in the largely libertarian Republican Party there want to be involved, abortion restriction kind of stuff. Governor Ayotte, who's the current governor of New Hampshire, don't know. I don't know too much about her stance on life and abortion issues, but an interesting note that about 20 years ago there was a New Hampshire parental notification law on the books on abortion that a federal district court found unconstitutional. And then I believe the First Circuit upheld that. And Governor Ayotte at the time was the Attorney General of New Hampshire. So she was actually involved in opposing that decision and trying to protect the parental notification law on abortion. So I mean, she was the Attorney General, so it's her job to advocate for the state. But I think there's some sign that maybe on these kind of parental notification and conscience right issues, she might be more likely to support them, but we will see soon enough. Um, just want to quickly note the importance of these kind of defensive laws as a bare minimum. As much as I would like to see fewer abortions or no abortions, ideally, right? Procured in our nation. These in a regime where abortion is unfortunately the reality. These are bare minimum protections that should be common sense, right? Protecting doctors from being forced to perform abortions, right? Doctors who take an oath to do no harm should not be required to kill unborn children. If they have any kind of objection to that, I think that should be a common sense protection. Very skeptical of these life of the mother emergency laws being used to kind of fight against the conscience right of doctors. And then on the other one, I would just note that criminalizing a non parent from bringing a minor to have an abortion, again, should be common sense. There's a clear way for one to protect parental rights, right? If you're a parent, you should know that your child is pregnant, that your child is considering having an abortion and killing her unborn child. But beyond that, I would also say that, and again, I'm not a niche expert here, but I have done some work in like against sex trafficking and human trafficking, and it's pretty well known that this is common practice that adults who are not parents driving minor girls to get abortions without parental consent is a common practice that accompanies sex trafficking. It's a horrible way to keep the sexual lives and sometimes the coercion of minor girls out of the, so that these practices are not being, made known to their own parents. So, for again, a whole bunch of policy reasons, but especially these are just common sense to protect minor girls, to protect doctors. It's not even an abortion restriction. I think these are pretty mild. Of course, anything that touches on or looks like an abortion restriction is going to be attacked by the pro-abortion lobby. But mild laws, hopefully, we will see these enacted into law in New Hampshire. And Joseph, before we wrap up, you have any thoughts on these two bills on what's going on here?
Yeah, so you mentioned a little bit about some of the criticisms that these bills have faced, and I want to take a little bit more time to note them and some of the implications that they have. So, not unsurprisingly, they're largely portrayed, like you mentioned, by pro-abortion groups as attempts to curtail freedom, quote unquote, reproductive rights, as these radical anti-abortion ideas. As much as I wish they were, it's not what's happening here. Um, but the ACLU of New Hampshire criticized the transportation ban, HB 191, as quote targeting an individual's access to abortion within their own community and those who support them, end quote. Another group called Reproductive Equity Now describes these bills as, quote, making New Hampshire a worse place to live and decide if, when, and how to begin a family, end quote. Like you said, the reality is that these bills only promote parental rights and medical conscience rights. Nothing about them are actually making abortion more illegal in New Hampshire. Again, I wish they were, but that's not what's happening here. Uh, that it goes to show that these attacks against these bills, how they frame these bills inaccurately, show the mainstream abortion industry isn't caring about actually planning parenthood. It just wants more abortion. If it was really about a parent's right to choose, why attack laws that protect the right of a parent to choose what their kids' medical procedures are, or even just to be involved in those decisions? So, like you mentioned, these are not laws that curtail abortion, and the fact that they're being attacked by pro-abortion groups as doing so shows a little bit of the reason for those attacks and what's really going on in some of those ideologies.
Yeah, no, it's a good point and a good note to end on. One of the founding common themes of this podcast is that the so-called demand for tolerance of the opponents of religious liberty and of pro-life policies, tolerance quickly becomes coercion because here it's clearly not about tolerating abortion or tolerating dissenting views. This is about coercion, right? This is the abortion regime, and if a doctor dares to say, "Oh, I don't want to participate in that," you don't want protections from him for him. If a minor child's parents say, "Well, we want to be involved in our children's decision about things like pregnancy," and you say, "Well, no, you have no ability to be involved in these." Again, these are not matters of permissiveness and tolerance. These are coercive, and they are attempts to allow no dissent from the abortion regime. Quite frankly. All right. And with that, we thank you for joining us for another episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we appreciate it if you would like the podcast and subscribe to our channel on YouTube, Spotify, or wherever you are listening from. We hope you'll join next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith based nonprofit organizations. And to see more of the work we're doing on religious liberty and nonprofit law, we always encourage you to check out what we're doing and to support our work at napalegalinstitute.org. We'll talk to you next week. Thank you for joining us, and God bless you all.